Good afternoon. My name is Bob Williams. I'm the Dean of the Faculty of Law at Monash University, and I'm acting as MC this evening, and I'm extremely pleased to be able to welcome you all to this evening's lecture, which is hosted jointly by the Monash University Law School Foundation and the firm of Cause Chambers Westgarth. It's particularly pleasant for us to have the opportunity of having David Murray speak to us this evening. The State Bank was a bank which always enjoyed a very close relationship with the Monash Law Faculty and was very supportive of the faculty, and we're appreciative and very pleased of the fact that that relationship has been able to continue under the Commonwealth Bank, and look forward to a further continuation of it. I am unable to resist the temptation of commenting on the title of this evening's lecture, which is Banking Under English Law, Roman Law, or Regulation by Harassment. In my view, one of the sad things about the curricula of all Australian law schools is the fact that the place of various forms of history, legal history and Roman law, occupies a less significant place in those curricula than used to be the case. As I watched with fascination and occasional disbelief the various antics of the 1980s, one thought which occasionally used to pop into my mind was these people have no understanding of history, for if they did, they would know where it was all leading. I'm absolutely delighted to learn that the Commonwealth Bank is now under the charge of an individual who certainly has an interest in history. Without more, I'll take the opportunity of inviting Barry Dunstan of the Financial Review, who's very kindly agreed to introduce Mr. Murray.
Barry O'Callaghan from Cause asked me to introduce tonight's speaker. I assume he asked me because he wanted someone who would be nice to a banker, someone like a journalist, a breed that notorious for being nice to bankers. Anyway, David Murray, the Managing Director of the Commonwealth Bank, is a rare banker these days. He's rarely in the news pages, and he isn't yet instantly recognisable if he does appear on television. I suspect that means he's a lucky banker in these days when people seem to be headhunting the bankers. In fact, it seems to me that he's been lucky several times in his life. Back in April, when he was appointed Managing Director, when the announcement was made of his appointment, he told the story of how he came to join the Commonwealth Bank. His father, it seems, was an inspector with the Commonwealth Bank, and he thought that it would look improper if David joined the same bank. In fact, his father advised him to join the Bank of New South Wales, Westpac of course, because his father said it was a good bank. I bet David has been pondering recently how his life might have been different if he'd actually taken his father's advice. However, going on his instincts in 1966, he joined the Commonwealth, and as a result, he hasn't seen his chairman and 4 of the other board members resign recently. I suspect perhaps, though, that some other bankers may not envy him having the Secretary of the Treasury sitting around the board with him, and of course it would be very interesting if the main shareholder sent along someone like the Prime Minister to act as proxy holder at the annual meeting. However, I suspect that David would probably cope with that in the same way that he's clearly coping with one of the biggest jobs in banking, and he would do it calmly and efficiently. He took over as Managing Director of the Commonwealth, as I said, in June this year, but he was already a veteran of the bank with 26 years' experience, including several years in the branches, after he joined the bank, aged only 16. At 43, he's the youngest to have held the top post at the Commonwealth Bank, which perhaps tells us something about the bank's new outlook, but it also tells us a lot about his ability, and I suspect we're about to receive a glimpse of that in his talk tonight under the title already notified, Banking Under English Law, Roman Law, or Regulation by Harassment. Would you please welcome David Murray.
Well, Professor Williams, distinguished guests, ladies and gentlemen, and particularly to Barry, thank you for those opening remarks, and thank you for your invitation to deliver the Monash University Law School Foundation lecture. I'd like to greet in particular Don Nissen and friends in Brisbane who are watching this by modern electronic means, and hope they too enjoy the lecture. I'd particularly like to thank Cause Chambers Westgarth for generously making available these facilities and coordinating this evening's function. And in response to the opening comments, I'm indeed grateful to the legal profession, or we should all be grateful to the legal profession for the support which you continue to have from the successor to the State Bank of Victoria, because it was by dint of an important legal process called universal succession that we did not have to rearrange any of the contracts of the State Bank of Victoria when we acquired it. At the outset, I should clarify any incorrect impression that might have been given by the topic of tonight's address, that you might be about to be treated by the Managing Director of the Commonwealth Bank to a dissertation on the origins and development of legal systems and the law. My own formal legal education didn't advance much further than Carlisle and the Carbolic Smoke Company. Perhaps the reason why this case stays in my memory is because of the importance its importance in the development of contract law. Whether under the common law system we've inherited from English law, or countries operating under the civil law system derived from Roman law, enforceability of contract remains fundamental to the banking system. Australian banks are rated highly by international standards. The current stresses on the economy, caused partly by asset devaluation after 20 years of inflation, have to a large extent been absorbed within the banking system. In no instance was any Australian bank depositor or the viability of the financial system put at risk from a bank's problem assets. Despite the inherent protections in our banking processes, various groups have been active in endeavouring to question contractual relationships in the banking system. This is not surprising given the nature of the recession and the trend towards greater debate and information exchange in the community. To the extent that it's directed towards a concern to improve service to customers, it is to be applauded. But the consequences of this questioning of fundamental contractual arrangements are naturally significant, and I would like to explore them with you tonight. My understanding of the aim of our legal system is to enable citizens to go about their business freely, with the protection of sound and comprehensible rules that ensure their personal safety, the protection of their assets, the certainty of their contractual undertakings, the protection of their privacy, their equal treatment with other persons, and the preservation of freedom of competition in their businesses. The issue to be addressed is not whether the current process of change will succeed, but whether in achieving reforms we may undermine some of the inherent protections in the existing system at a future cost to the customers whose lot we are all trying to improve. Let me first go to the operation of the banking system. The process of financial intermediation undertaken by banks involves the smoothing of surplus cash holdings in the community and the sharing of default or credit risk with bank owners on the basis of a net benefit to the community over barter or pure cash trading and wealth storage. This process comprises three principal elements, namely the taking of deposits, the provision of credit, and the giving and receiving of value through the payment system. The prerequisites to the operation of these services are a set of contracts between a bank and its customers, each serving one or more of the above-mentioned three functions. For example, a cheque account with an overdraft provides deposit services, a payment service, and the provision of credit, whereas a term deposit provides only a deposit service. Nextly, higher than normal financial leverage, since there would obviously be no net benefit if banks, in lending money, had to maintain the same financial leverage as each customer should themselves maintain. Next, high operating leverage, which I should say is not well understood, but which is necessary in the conduct of banking operations where the range and number of transactions is large, requiring multiple sets of complex procedures and involving contracts with large numbers of customers, as well as daily processing of transactions for very high aggregate values in relation to the capital and monetary assets and liabilities of the bank. That is, one error spread over a large number of transactions, a large number of contracts, can be potentially financially damaging to a bank. One flash and we're ash. Lastly, we need confidence in the banking system which, in the event of changes in perception about capacity to pay on demand, can be rendered useless by a run. In meeting each of these prerequisites, the banking system has evolved over the centuries by establishing controls to minimise the attendant risks. We are a risk business, not a safety business. These controls cannot eliminate the risks since the intermediation process is designed to shift risk, then manage it on a basis which the community could not otherwise manage. The safeguards we have developed fall into two categories. First, under the Australian Constitution, legislative power in relation to banking, with the exception of state banking, is conferred on the Commonwealth Parliament. The Commonwealth has exercised its power to legislate for banks under the Banking Act. This Act authorises bodies permitted to carry on banking business and imposes on such bodies a range of prudential, financial and accounting requirements. Let me just divert there and point out that we were recently criticised for not conforming with accounting standards. I'm sorry to say that we're only conforming with the Banking Act and the accounting requirements in that. These requirements are administered by the Reserve Bank of Australia and are designed to ensure the financial strength of all bodies permitted to operate as a bank and underpin the entire banking system through the essential requirement of the protection of depositors. This statutory protection of the system, whilst not a guarantee, has two components. First, deliberate limitations on entry into the industry, limits on the percentage of bank ownership, and effective authority invested in the Commonwealth Treasurer to administer or otherwise deal with banks so that, if necessary, a crisis of confidence can be addressed flexibly. You have not got time if there's a crisis of confidence, and the Treasurer must be able to act. That is the reason for the system we have. Secondly, prudential supervision by the Reserve Bank, which, like other central banks, adopts, broadly speaking, 5 basic tests embodied in the acronym CAMEL. They are capital adequacy, which is the fundamental underpinning of a bank; asset quality, which goes to the credit management process of a bank; management, to ensure that there is the requisite experience and know-how in the conduct of operations; earnings or profitability, which supports continuation of business and maintains the capital base; and liquidity, which is a buffer to cover the normal maturity mismatch between deposits and loans. Second, if I can go to the second leg, the banking system, like any other industry or activity, requires the underpinning of a legal administration which gives confidence as to the certainty of contract. Since banks by nature have the potentially dangerous mix of high financial leverage and high operating leverage, because their business consists almost entirely of numerous, in our case millions, of customer contracts, then the operation of the statutory protection of depositors ultimately relies on the enforceability of those contracts. That is, we cannot separate the first aspect of protection through the Banking Act and the prudential controls exercised by the Reserve Bank from the second arm, which requires valid and enforceable contracts for that protection. In dealings with some of the people involved with proposed legislation and or codification of banking practice, it has become quite clear to me that the need to consider both aspects of protection is not widely understood. Let me just divert there to give you some examples about the relationship between some proposals that are around and the 5 elements in that acronym. If we look at capital adequacy, it's clear that that people involved in the Uniform Credit Bill do not understand or are not prepared to understand that forfeiture of credit charges can render a bank capital inadequate. This has been the case in New South Wales with 2 banks where there have had to be significant about-faces to resolve positions where hundreds of millions of dollars might be forfeited. In terms of asset quality, we are at risk of moving to a system where the liability falls to the lender for having lent somebody money. It is suggested it could be our fault that somebody borrowed money. That might, in very rare circumstances, have some basis, but widely spread is a very dangerous precedent for the banking industry. In terms of management, I think the process of some reform would be to remove decision-making from the management of banks. When I buy a car, I don't flip open the bonnet, take the head off the motor and check that the automotive engineer got it right. I prefer to have the comfort that people who run auto companies have good automotive engineers. In terms of earning stability and profitability, the hidden cost of compliance with much of the regulation about has been totted up by the Australian Bankers Association and comes to tens of millions of dollars in each year for banks to comply. Now, we don't have to whinge about that if we don't want to. The only reason we do is that that cost goes to our customers. Lastly, in terms of liquidity, it's been suggested that all depositors should be paid the top rate of interest for any parcel of money for any term. If were we to do that, we would be taking banks to a new level of liquidity risk in the system. An interesting example is deeming accounts. The rate paid on deeming accounts is closer to the rate paid on term deposits than on demand deposits. Yet if we don't pay the deeming rate, the goodwill we have established with our customers by dint of good service over decades will be expropriated by virtue of that arrangement. If I could turn then to the banker-customer relationship. When a customer and a bank first conduct business with each other, a contract is formed, and depending upon the nature of the ongoing banking services conducted over time for that customer, a whole range of practices and rules will apply to the financial transactions to be effected, and these rules form the terms of the contract. A personal customer may have a fairly simple use for his or her bank, such as the conduct of a cheque account, but even this apparently straightforward service brings into play many principles governing the opening and closing of accounts, stopping payment of cheques, furnishing and withdrawing of authorities, time for payment or dishonour of cheques, appropriation of debits or credits between or within accounts, when accounts may be taken as settled, set off, or combination of accounts, overdrawing of accounts, rights to charge interest, order of payment in or out of accounts, countermand of payment, right to dishonour, banker's lien, when banks have or have not a mandate to pay, special rules where companies, trusts, joint or partnership accounts may be involved. This is by no means an exhaustive list. Where a customer wants other services, for example, electronic or telegraphic transfers of funds, issue of bank cheques, travellers' cheques, safe custody facilities, arrangements for the issue and negotiation of letters of credit, other practices apply, binding both the bank and the customer, but still governed by the banker-customer relationship. Case law confirms or clarifies whether particular transactions in the set of facts before a court are carried out in accordance with accepted banking practices, and the courts at times will lay down what banking practice is on a matter in particular areas and the duties and rights of banker and customer. Classic examples of this are the duty of confidentiality and the recognised exceptions outlined in Tournier's case, the application of the rule of payments in or payments out of accounts in Clayton's case, to running accounts and the duty of a customer when drawing a cheque to take reasonable care not to facilitate fraudulent alteration as set out in Commonwealth Trading Bank and the Sydney-wide case. Where rules are developed by the courts, such as the equitable doctrine of unconscionability, or where statute law imposes obligations such as Section 52 of the Trade Practices Act, the courts construe the effect of these changes on the banker-customer relationship in particular cases. The financial transactions conducted by banks for the multitude of personal and business purposes of the range of customers of banks require a set of rules that can operate in and be adapted to an infinite number of different factual situations. This is the reason for the banker-customer relationship being founded on a contract comprising rules developed from banking custom and usage, imposing duties and conferring rights on both banker and its customer. In relation to the doctrine I just mentioned, we have had most difficulty with third-party guarantees. That has set up for us, and I believe the community, quite a dilemma. The process of decisions of the courts on third-party guarantees has generally run against the banks. But the point is that if this gets to the point where we find it more difficult to provide loans secured by third-party guarantees, there are many small businesses in Australia that will have difficulty getting access to capital. The reason that they use third-party guarantees is because they want to structure their business for multiple relationships, tax planning, joint capital infusion, or many other reasons that leave a third-party guarantee for lending as quite an appropriate method of funding the vehicle that it is in their best interest to construct. So we have to be careful in cases such as this that we try to retain the essential element of third-party security and don't constrain the system and the availability of capital to it. Under English law, a promise supported by a consideration is enforceable. The leading common law text on contracts, Chitty on Contracts, states, the main justification for the legal enforcement of promises is an economic one. Trade and commerce would be seriously impeded if the law permitted a promisor to break his promise without at least placing him under an obligation to pay compensation for the loss occasioned by his default. In the civil law jurisdictions which adopt Roman law, where an agreement has been reached between the parties, the law will enforce the contract, and the principle of certainty of contract is as enshrined in the civil law as strongly as it is by the common law. While the balance sheets of industrial companies are dominated by their productive resources, banks' balance sheets are dominated by monetary assets and liabilities, which are no more than a set of contracts between the banker and the customer. Those contracts require an ongoing account relationships, and for the reasons I've outlined earlier, the viability of a bank requires a good set of contracts, well conducted, and, in the event of dispute, properly protected by the common law process. That protection, I should add, extends right into the dispute resolution process. My amateur understanding of the rules of evidence is that the disputing parties, I should say, will generally pursue their own interests, and the court process with those rules of evidence is designed to compensate for such behaviour and get at the facts. Yet in many instances we've found ourselves at a great disadvantage in the provision of evidence and the calling for documents. Let me highlight some further points about this contractual position. A bank is required to repay its depositors in accordance with the contractual terms of the deposit. The relationship of banker and customer is that of debtor and creditor, and not that of trustee and beneficiary. A bank is its depositor's creditor. The other side of a bank's operations is the lending of money. A bank's assets are predominantly the value of its credit contracts. Loans are merely contractual obligations of a lender to lend and a borrower to repay, according to the agreed terms. Securities or guarantees also contain certain contractual obligations. In deciding whether to lend the depositors money or not, a banker makes an assessment of the credit risk in much the same way as an insurance company makes a considered assessment of the risk before accepting it and taking a premium. This assessment is calculated on the basis that the fundamentals won't vary on either side to any great extent during the term of the loan. Accordingly, the whole value of a bank's business depends on the principle of certainty of enforcement of those contracts, and a bank places fundamental reliance on the law and the legal system to establish the ultimate value of its assets. It does not seem a very profound statement to say that the value of a contractual obligation is its legal enforceability, but it is the steady erosion of the principle of certainty of contract as affecting banks that is of some concern. Banks' high financial leverage means that for every $100 of loan, there's usually about $5 or $6 of capital to support it, with no possibility of varying the liability to the depositor, unlike, say, the position with a managed fund. This means that if there was only a 6% loss of value of loan assets, it could render a bank capital inadequate. At current market interest rates, this amounts to only 6 months' interest. Where legal confusion causes delay or additional cost in enforcing contracts, the cost to a bank's capital base can be significant. If contracts are rendered unenforceable through some change in the law, then only 6% of contracts need to be written off before capital is absorbed. As explained earlier, the banker-customer relationship lies in contract governed by a flexible set of principles implied from custom and usage, established and developed over the centuries, and which continues to develop. There is no statute dealing directly with the subject. Over time, this has produced a stable, flexible base around which the range of complexities in the conduct of bank accounts are able to operate. To attempt to codify all the rules in a detailed written document would create, in the longer term, uncertainty rather than certainty. The uncertainty would arise because there would be a need to interpret a set of words rather than a set of principles. The words chosen to describe at any given time particular rules governing some of the rights and obligations of banks and their customers may not be appropriate to a particular banking service and would not necessarily produce a just result in dealing with a different set of facts in the future. I would anticipate that a customer of a bank would not be better off under such a regime, and the written processes necessary to amend written words as banking evolves and changes would impede the provision of banking services and would, I think, ultimately be unworkable. I refer to this point because there have been exponents of the view that there should be extensive details of the banker-customer contract written into a code. The point is that in a relationship as complex and diverse as that between a banker and customer, any attempt to produce a comprehensive contractual document is unlikely to aid the fundamental requirement of certainty of contract. Where there are written contracts governing banking services, for example, credit card conditions of use, as well as various types of loan and security documentation, the basic principles applicable to the banker-customer relationship still apply to these banking services. Let me look now at proposals to vary contracts. The new age of regulation in Australia appears to be at a critical stage. Despite considerable progress by Commonwealth and state governments to deregulate the economy through microeconomic reform process and other means, there has been a significant increase in new regulations in a great many areas. Developments in the finance industry provide an important example of how regulation, and now the threat of re-regulation, can operate against the interest of a majority of the bank's customers. The tight controls of the 4 post-war decades constrain banks in their ability to lend in forms and to the extent sought by borrowers. Non-bank financial intermediaries stepped in to fill the breach, and since these were outside the prudentially controlled system, it had the effect of exposing customers to more risk than had been envisaged or desired by the regulators. In the minds of some groups, perhaps I should say there that the drift of the operation of the finance system to non-banks meant that more and more people involved in it were being taken away from those protections in the Banking Act. In the minds of some groups, financial deregulation appears to be equated with a policy of laissez-faire. They allege that deregulation has undermined or even abolished basic consumer protection. This is paradoxical given that much greater attention than ever before is now given to customers and their demands. Today, customers are sovereign, because if one section of our industry does not try to meet their needs, others will. Despite these benefits, there are moves to reimpose a regulatory order on the financial sector. The heavy price paid under the previous regulatory regime in terms of limited access to credit for most people and poor utilisation of valuable resources has been conveniently forgotten. These moves to regulate, formally or informally, may arise from such things as these. If you don't do it, I'll regulate. Or perhaps, interpret the contract my way or I'll tell the media, which will damage your reputation and business. Or, if you want us to stop bashing your reputation, agree to this new legislation. Or, if the community can be convinced that banks are bad, then any populist cause will have greater chance of receiving legislative backing. One government told me at one stage in discussing the Credit Act, "You're right, but I can't support you publicly because everyone knows banks are bastards." Another difficulty is that the proponents of change generally argue that their underlying concern is one of equity. Equity is terribly important, and it may well be an appropriate aim, except that the pooling of interests required to achieve the intermediation process requires itself that some individual interests are necessarily foregone. For example, the cost of a credit card facility for an individual with very low credit risk is unlikely to recognise in pricing that particular individual's credit rating. We could not operate a credit card system on that basis. The activity used by certain groups to achieve their objectives is, in my view, best described as regulation by harassment. Groups frequently allege, without foundation and often in a blaze of publicity, that bank practices are defective or that banks have acted improperly towards them. On almost every occasion when we examine these matters internally or they finally get to court, the allegations cannot be substantiated. I'm concerned about the escalating cost to banks and therefore their customers of funding the activity necessary to receive and respond to pressures from these sources. This kind of activity is not a productive use of our resources, does nothing to improve our customers' position, and hinders our introduction of innovations to the ultimate detriment of all of our customers. Common law principles in banking practice have combined to drive the banker towards considering the best interest of the customer at all times. It's easy, isn't it? Otherwise we'd lose them. Attempts to interfere in this process could badly damage the fabric of these arrangements. We understand fully that our interests and our customers' interests are the same. This notion does not, however, trigger misunderstandings in discussion about lending. We do no good for either our customers or shareholders by extending credit imprudently. In some cases, groups of borrowers who have no legal or commercial basis to resist repayment of what they borrowed, such as a minority of foreign currency borrowers, have combined to exploit every tactical advantage against banks. These tactics have included generating publicity through the press, who often report unverified the complainant's version of events, lobbying politicians to take up their cause, and adopting tactics of harassment against banks, such as disrupting annual general meetings or persistent writing of letters to senior management and directors of the bank. For their part, banks have been reluctant to enter the debate because of the requirement of confidentiality in the banker-customer relationship. This sometimes gives the impression that the defaulting borrower's version of events is correct. and that the banks have something to hide. Whilst banks have historically been reluctant to defend themselves in the media, we take the view that if any defaulting debtors publicly attack the bank, they have waived the obligation of confidentiality, and the bank is therefore entitled to publicly disclose the true facts. In court proceedings, the rules of discovery of documents have been exploited by some complainants in an attempt to obscure the basic issues and facts of the case, entering into arguments with banks over internal bank documents they claim should have been discovered from amongst the myriad of writings stored in the dispersed files of large financial institutions. Such claims are an example of abuse of reasonable procedure, where discovery is used almost as a substitute for the due process of law. Some lawyers, when acting for people in a dispute with a financial institution, threaten to take the matter to the media if they don't get what they want. Such action undermines respect for lawyers who are engaged to sort out legal issues objectively and impartially. Assuming the role of an activist with such threats, but still claiming to be entitled to the respect and privileges afforded to the legal profession is, I believe, unethical conduct, and I urge the profession to take a stand against it. Perhaps I should give you an example here of one action in which we were involved. My understanding was, from Law 101, was that an affidavit is defined loosely as a sworn written evidence to be used in court proceedings. Yet we were once confronted with a damaging media story based on, quote, a draft unsworn affidavit, unquote, provided by a practising solicitor. Fortunately, we got the cameras turned off before the thing hit the evening news. Journalists, politicians and others who uncritically take up the cause of certain borrowers in default may ultimately do a great disservice to defaulting debtors. Having someone else to blame for one's own losses prevents or postpones the need to face up to the fact that the reason and the ultimate responsibility for the loss almost always rests with the borrower. Often, substantial legal aid to the borrowers is provided at great cost to the taxpayer because of the publicity and noise generated about the case. One such example was settled in court only recently. After long drawn-out court proceedings, bitterly fought by the borrower and fuelled by activists and journalists, the court has confirmed the liability and decided in favour of the bank. We get no comfort from this. With dispassionate and sound advice, this borrower and others in similar cases may have faced the inevitable position years earlier and been able to recover something from their initial bad business decision. On occasion, disputes with customers cannot be resolved in direct negotiation or by mediation, and in consequence, these must be referred to the courts. That right should not be fettered by pressure brought upon a bank by the media or others on the basis that the banks happen to be large business concerns. I have already pointed out the sensitivity of the prudential requirements of banks, and that both customers and shareholders have a vested interest in the viability of the banking system. Specific instances of regulation by harassment are many. I propose now to concentrate on those regulations specifically directed at banks and not deal with corporate, industrial and other forms of regulation to which banks, together with most other companies and businesses, are also subject. Firstly, the credit legislation. In the mid-1980s, legislation came into operation in some states regulating personal loan contracts and credit card financing offered by financiers, including banks. The legislation imposed a technical regime as to matters of detail to be contained in notices and contractual documents, and in procedures to be followed when granting this type of lending and enforcing debts. The blueprint for this legislation was, in effect, legislation applying to pawnbrokers who lent at high and even exorbitant rates of interest. Based on 19th century English usury laws, the legislation was designed to curtail and hinder the role and activities of pawnbrokers, an objective which should be the very opposite of what today's society requires from its banking system. Such legislation was unnecessary for banks, since these were already providers of finance for personal purposes on normal and straightforward lending terms, at market rates of interest in a competitive system. At the time this legislation was being developed, the Commonwealth Bank, and I believe also other banks, put considerable resources into redocumenting contracts and changing procedures to provide such historical banking services to comply with the new laws, although the existing arrangements were already satisfactory. The credit legislation incorporated, without any demonstrated justification, punitive provisions for non-compliance with strict regulatory requirements. These operated automatically even where there was no detriment to borrowers or where non-compliance was through an unintentional error or flawed interpretation of this technical and bureaucratic legislation, which unnecessary procedure or step in the transaction was unforeseen by banks and even by government at the time of its enactment. Let me give you another case here. We received from a legal aid centre a complaint about a personal loan contract because it did not comply with the form of the Credit Act. The reason was that we had put stamp duty, we had a fixed stamp duty to our contract, and that was not in conformance with the Credit Act. I believe the stamp duty was $1.50. The only way that we resolved the issue, and this is a state act, was to get a ruling from the Stamps Commissioner that we should indeed put $1.50 on the contracts. The consequence of not sorting out that particular case would have been that we would have forfeited all credit charges on all similar contracts that we had stamped. That would have borne no relationship to the damages suffered by the borrowers. Under this legislation, the bank automatically loses its right to be paid the interest on a loan where a breach has occurred. That is, the bank's total income in respect of a particular loan or classes of loans is wiped away, not just the profit, while the bank continues to bear the full interest on the deposits that were necessary to fund the particular loan. In the case of a technical mistake across a whole category of types of regulated loans, the bank potentially stands to lose amounts that, for some banks and in some instances, could have a significant effect on the bank's underlying financial position, that is, its capital. You can imagine the concern of the New South Wales government when the dispute that its own bank, the State Bank of New South Wales, became involved in was for hundreds of millions of dollars, very significant in relation to the total capital of that bank. The legislation is drafted so that the power to penalise banks with the automatic forfeiture of interest is vested in state and territory credit tribunals. The members of these non-judicial bodies are not bankers, nor are they necessary persons who have a background or understanding the financial or legal system. The appointees to these tribunals are mainly persons whose dealings and associations have been with bureaucrats or quasi-government groups representing sectional interests. The objective of these groups appears to be to push the system as far as possible to assist debtors escape their contractual obligations to repay what they borrowed. This failure to honour an obligation to repay what was lent has been portrayed in the media on occasions as a contest between some innocent underdog fighting the large and uncaring bank. Never do you hear that the money lent to these defaulting debtors came from the full range of bank deposits, which includes the savings of many ordinary Australians. It is interesting to witness that in parts of the community the attitude to avoiding debt is changing. Increasingly, ordinary customers are asking why they should, in effect, bear the costs and are seeking a return to perhaps old-fashioned but tested values that if you incur a debt, you ought to repay it. You might have seen the 60 Minutes program recently about the Leyland brothers in New South Wales. A significant proportion, about half, of all the mail we received after that program was in support of the bank recovering its debt. And that is different from the position some 12 months ago. Weighting the legislative regime in favour of defaulting debtors creates a distortion in the process of financial intermediation, which must take into account the interests of depositors and shareholders, as well as borrowers from banks. More recently, proposed uniform legislation which would impose further unrealistic restrictions on bank personal lending, has been proposed. Drafts of this proposed new uniform credit legislation, which by the way isn't uniform because the states can't agree, continue the automatic loss of interest for breaches of the legislation, as well as containing other unwarranted intrusions into the normal business of banking. In particular, powers are to be given to credit tribunals to impose interest rate adjustments. They won't impose them on both sides of the book, I can tell you. And to reopen contracts, infringing the principle of certainty of contract. The draft legislation proposes a substantially wider class of lending to be regulated, including personal overdrafts. If enacted in its present form, the legislation would regulate about 33% of the Commonwealth Bank's lending from the current figure of only 3%. We estimate that this proposed legislation would drive up interest rates by anything up to 0.5% to cover the necessary prudential requirements in case of a potential system error, plus the additional administration costs of lending in such a regulated environment. The imposition of the proposed regulation on overdrafts would mean that banks would be effectively prevented from honouring customers' cheques drawn outside formal overdraft limit arrangements, because any further advances made outside arrangements could well be unenforceable or fall outside the provisions of the legislation as a loan. Such provisions are clear examples of a direct disadvantage to a range of bank customers by the proposed regulatory regime. One has to question whether the imposition of a technical regulatory procedure extending over a significant proportion of a bank's loan book under a system administered by tribunals and bureaucrats will operate to support the fabric of prudential supervision of banks, or wear it dangerously thin. In discussing these proposals with some of the ministers and their departments, we pointed out that if you forfeit credit charges, you only need to get to half a year's credit charges on a loan contract to take out all of the capital support for that loan. We were told then that that doesn't matter because if the amount is significant, then the credit tribunal can defer the forfeiture of credit charges. That does not matter one iota to a credit rating agency. The fact that a bank has a contingent liability to repay hundreds of millions of dollars of credit charges will not prevent Standards, Poor's or Moody's from downgrading a bank and significantly impairing its liquidity and its fundraising processes while we all hang around waiting for a credit tribunal. Next I want to get to is the code of practice. Largely as a result of lobbying activities of sectional interests, political pressure is being mounted against banks to adopt an externally imposed code of banking practice. This is the voluntary code that we're not going to get to volunteer. We have not yet seen precise details of what the government group established to draft the code will produce. As currently being developed, the industry has been placed at arm's length. That's technical for being left out. And on a par with various sectional interest groups. I know of no other industry where it is proposed that the very elements that form the basis of its customer relationships are to be determined by a small group of bureaucrats. As outlined earlier, the banker-customer contract has been developed in common law over a very long time and contains a range of flexible but sound protections for both banks and their customers. We believe that the financial industry, guided by good statutes in the common law, is well able to secure appropriate self-regulation. The group developing the code has been advised that while the Commonwealth Bank will agree to commit to fundamental standards applying in its business, it will not commit to an attempt to codify the law, thereby locking banks into a document which overrides the existing contracts we have with many millions of our customers and specifying the manner in which banks should offer their services. This would make it difficult for the bank to innovate, develop service for the benefit of all customers, and to compete in the market. Next is the Ombudsman. The Commonwealth Bank set up the first, and I believe the best, internal procedures to resolve disputes with customers. We process about 800 million transactions a year and receive about 4,000 complaints through this process. That is a very low complaint record. We found these procedures result in complaints being resolved cost-effectively, rapidly, and with regard for our ongoing relationship with the customer. For these reasons, I believe that the best dispute resolution occurs when handled directly. If there is to be an external system, such as we have with the Australian Banking Industry Ombudsman, then the necessary protection to such a scheme's independence arises from the Ombudsman being able, with certain checks and balances, to determine what comes within his terms of reference. However, once that route is selected, it should be recognised that the banks who agree to abide by the decisions made have effectively given away their contractual rights, most notably the right to seek redress in the courts and to have the matter resolved in accordance with the contractual terms and accepted banking practice. But in setting up the scheme, we also set up a council and a board to ensure that the terms of reference and the outcomes of the scheme ultimately would be consistent with good banking practice and the banker-customer relationship of which I've spoken. We also limited the scheme to claims of less than $100,000 and to personal contracts, and excluded disputes over lending transactions. This says lending transactions here, but the excluded disputes are in fact over the credit decision itself. There can be disputes admitted on lending transactions. Next, confidentiality issues. The relationship between banks and customers must obviously be a confidential one. Banks have a contractual duty to keep confidential all aspects of their dealings with the customer, including the nature of the transactions through the account or the details of securities held for the customer. The duty is implied as a contractual term, and any breach gives rise to an action for damages. Exceptions of the duty of confidentiality are recognised, including where disclosure is under compulsion of law. Banks have been faced with increasing pressures from regulatory interests in this area. It took over 50 amendments to the original privacy legislation to allow banks to continue to make the time-honoured, prudent credit inquiries normally performed before banks embarks on any personal lending transactions. I'm sure you agree if you got a deposit in the bank, you would want us to continue to do that. The duty of confidentiality is ingrained in the banker-customer relationship, is a term of the contract, and is already observed by banks. Cutting across the fabric of the banker-customer relationship is the tendency to require that banks be compelled by law to disclose customer details to government agencies. This overrides the fundamental contractual duty, thrusts more work and expense upon the banks, and is a direct blow to the rightly publicised obligation to preserve secrecy concerning customers' accounts. I should mention here that I'm not referring to the recent issue of the leakage of information to certain government departments. In the bank's instruction manuals, there are 66 Commonwealth, State and Territory Acts listed as compelling disclosure of customer information to relevant government authorities. This does not purport to be an exclusive list, and it continues to grow. Of particular significance is the requirement under the Cash Transactions Reporting Act for bank officers to make out a report to the relevant government agency whenever a bank officer has, quote, reasonable grounds to suspect, unquote, a breach of the whole range of Commonwealth laws. This imposes unrealistic obligations on bank officers and exposes banks to a serious risk of breaching their obligation to their customers should the banks make a wrong assessment of whether or not particular conduct is suspicious. With over 40,000 staff and millions of accounts, we in the Commonwealth Bank have not found it easy to establish working guidelines to cover all possible issues. I don't know what our tellers are going to think when the next suggestion comes up that they can be subpoenaed under these arrangements. Further, it is inconsistent with the bank's aim of developing a friendly relationship with and an efficient service for its customers to have legislative provisions imposed on them which require bank officers to be suspicious of their customers' activities. There's a parliamentary review expected shortly of the Cash Transactions Reporting Act as a whole. It is hoped that the review will critically examine the advisability of having a provision of this nature in our law. Almost all matters reported by banks, according to the government agency's own report, relate to taxation matters. These are really the job of the Commissioner of Taxation, who already has his own investigatory powers. Yet banks, at their own expense, are required to report significant cash transactions to a government agency and also to provide periodically a range of information about customer financial details to the taxation authorities. The cost of complying with these regulations is heavy, and it impinges significantly on our ability to concentrate on the type of service our customers value. Some other regulations. Over the last 10 years or so, banks have been made responsible to charge and remit financial institutions duty and debits tax to the revenue authorities. In other words, they've been forced to become tax collectors. Banks were required to set up systems at their own expense and are exposed to risk by reason of the technical and complex provisions of the legislation imposed on them. Let me give you another example. In setting up the legislation in New South Wales, after considerable discussion with the experts in the banks, there was an agreement reached that internal bank working accounts would not come under the financial institutions duty arrangements in New South Wales. We've recently been given a new interpretation by the appropriate official that they now are interpreted as coming under those arrangements, and to the best we can work out on a quick back-of-the-hand calculation, we're up for $20 million. Now, we're not up for $20 million, our customers are up for $20 million. But when we are criticised by officials, politicians and everybody else for having too wide a margin of deposit price or lending price over deposit price, nobody remembers to put in institutions' duty on internal bank working accounts. Under land tax legislation in some states, banks in their capacity as mortgagees of land can be liable to pay the mortgagor's land tax. There are also quite onerous liabilities imposed on mortgagees under environmental legislation, under which banks are held financially liable for the responsibilities of others. As with other instances cited, this increases the risk to the bank and must ultimately be reflected in higher cost to the customer. To conclude, I'd like to say that Australia has been very well served by its banks. They are amongst the best rated in the world and are of world standard in the provision of services. The soundness of the banking system has been demonstrated by its ability to absorb substantial loan losses in the current period of recession and asset devaluation, without affecting the underlying strength of the banks. The banking industry has been at the forefront of technological developments in the clearing of cheques, commercial paper, the provision of electronic banking services through automatic telling machines, FPOS and other electronic services. The Commonwealth Government's exercise of its banking power should have as its primary objective the encouragement of a competitive, efficient banking system within the prudential guidelines and without the need for excessive regulation. The ex-governor of the Reserve Bank, Mr. John Phillips, has stressed that intervention should be limited in its scope. In his words, if we were to tell banks to whom they should lend, or how much they should lend, or what type of loans or deposits they should offer, we would be taking on ourselves the role of boards and the management of banks. And to what purpose? I doubt that our judgment would be any better than theirs. The parliamentary inquiry into the banking industry confirmed the following. The community had benefited from deregulation. The Australian banking industry was of world standing. The industry was not unduly profitable by comparison to other industries and was competitive. It is relevant to note that this great increase in regulatory activity has taken place during a period when Australia has become more indebted and less competitive. We do not have the luxury of devoting the resources of the nation to drafting administrative any type of regulation that is not necessary. The existence of law reform process cannot be expected to be a watchdog and to prevent ongoing abuses of the system of lawmaking, and we all have to realise that the solution to any weaknesses in our laws lies ultimately with the whole of the community, and in particular its opinion leaders in government, the media, education and politics. In 1972, the Federal Parliament passed 1,268 pages of legislation. In 1989, 4,832 pages. In the 26 years that I've been with the Commonwealth Bank, I'm told that approximately 15,000 new laws have been placed on the statute books. Whenever there is an outside interference in a finely balanced and competitive industry, when resources are allocated according to principles other than those that have a commercial foundation, then decisions affecting the industry cannot be made by industry, and when those decisions cannot be made by industry participants, then efficiencies are going to be eroded and costs will accrue to the community as a whole. Finally, if I've left you with any impression that it should be that I am a committed supporter of the banking system and of the elements in the law and prudential regulation which we have to support it. At the very heart of the banking system is the banker-customer relationship. It is founded on contract, and it has weathered well. It has weathered well precisely because it has been certain, but with the flexibility of the common law and good practice permitting it to evolve appropriately with customer need. In an all-round sense, we have one of the best banking systems in the world, yet, as I have said earlier, the banking system is nonetheless finely balanced. It does not take much to tear at the fabric which protects it. Intellectual honesty and rigour demands that before important changes are proposed, let alone implemented, the sponsors should be required to demonstrate that their system, in all respects, is superior to the existing one. It is important that we support and elaborate the banker-customer relationship. We are doing that continually by adequate disclosure and customer contracts, by the innovations we're bringing to products and services, and by our preparedness to deal sensibly with disputes as and when they arise. Our motive is the interest of our customers and to deliver to them services which meet their needs and are valued by them. I'm sure this audience is well placed to appreciate the importance of providing valued service, but as importantly, it is well placed to understand that this is made possible by constructive development of the banker-customer relationship. That development must be secure, as it is with the present processes, and by the contractual foundation. Once again, thank you very much for your invitation to address you tonight, and I'll let the Chairman take over. Thank you.
Mr. Murray has very kindly agreed to take questions for 10 minutes or so. In asking questions, I'd be grateful if you'd identify yourself by name, and in the case of representatives of the media, if you'd also identify the organisation you represent.
Mr. Murray, my name's David Elson. Many of us are involved with large organisations, and I'm involved with several, and one of the great problems is that the individual dealing with a big organisation can be swamped, and that's where the regulation comes in the other way. And all of us as directors or senior managers, we go home at night and don't really think about a particular matter that's come up, but for the individual, it might be something that they're lying awake for months sleeplessly about. Now, while I think many of us fully understand and sympathise with the overall views that you're putting, how do you suggest that you do balance that so the individual does have some weight when he's talking with the individual bureaucracy?
Well, I think the tenor of my remarks really has been that it is never in any business's interest to ignore any of its customers, because the consequence of that is to have no business. The second point that I think I was trying to make is that whilst people think we're large, we are extraordinarily fragile. It does not take many adverse interpretations of the form of contract to get right at the capital base which supports a bank. So while the customer may think they have little power, the reality is that they have much more. Now, we try and address that in a number of ways. Our internal complaint resolution process has come out of all of the difficulties of the 1980s, which I think we need to separate out a little. Some of those difficulties are about people who got into strife because inflation led to far too much asset speculation in the non-traded goods sector. So that's a sort of a lending style of dispute. A lot of the other criticisms and disputes, though, arise from the day-to-day transactions of customers. And it might be the application of a fee, the way in which they were treated on the dishonouring of a cheque, could be anything. We've found that the regulation of the banking industry made banks extraordinarily sleepy in dealing with those customers. A very paternalistic, high-handed attitude to those customers. So one of the great things about deregulation was that we came closer to normal businesses in the understanding that that customer is sovereign. And if you don't deal with that customer, they will go away. And in fact, the churn of customers in the banking system is now much higher than it's ever been. But we also recognise that, unfortunately, the cost of access to the law is often prohibitive for the small customer. For that reason, we put great stress on the efficient and independent working within the bank of our complaint resolution process, and it was for that reason that we participated in the establishment of the Ombudsman scheme. But as you're probably aware, there have been banks who've sought either not to join that scheme or, having joined it on the basis of their concerns, have withdrawn from it. And I think I mentioned what risks we take by having such a scheme. I think ultimately the best system we have is not an expensive bureaucratic one for handling a particular problem that particular customers find it too expensive to have recourse to the law, but to promote in a community a system of intellectual honesty and ethical behaviour where people in the legal profession, people in management, understand the ethical side of what they're doing as well as the pure business side. I can't really offer a lot more than that.
If I may, could I just ask if Mr. Brian Hamley is here, if he'd go to the front desk, please?
Well, that's a very good question, but I didn't bring the calculator with me. Let me just clarify on the forfeiture of credit charges in the Credit Act, the credit bill. The point there is that there is no net benefit to anybody in forfeiting those credit charges. The damage done to a particular customer by a breach would very rarely extend to the whole of the credit charges ever charged under the contract. If I've got to provide $6 for every $100 of loan and the market interest rate is, say, $12, it only takes half a year's interest to be forfeited before the capital underpinning for that loan is lost. Yet it may not be $6 that represents the damage to the customer. It could be, for example, that, and I think it's fair, that if we had to pay damages, there would not be a problem, because it's on us not to make the error, and then we'll judge, you know, how often it's made by reasonable mistake, honest mistake. But the point here is that the forfeiture of credit charges is in no way connected in the bill to the damages done to the customer. And yet when I've tried to explain to these people that they are striking at the most fundamental prudential requirements on banks, that is their capital underpinning, and that underpinning is itself protecting depositors in the community, these people have put it to me that they're just sorry they can't do anything about it. So I say to them, I'm sorry, I'm not going to comply with your Credit Act. There are other provisions in other acts that say that it may not be valid under the Constitution anyway to have these form of proposals. But I would prefer to get there by reasoned debate with these people. What I put to you is if our customer incurs damages, we'll pay every time. But we shouldn't be subject to that form of penalty. The cost of taking away all of these requirements, well, there was tens of millions of dollars estimated by the ABA for complying across the industry generally. And, you know, I can't really say what it adds. The difficulty we have is that when we say it costs a lot, the community has been led to a belief that the resources available in a bank to do these things, meet forfeited credit charges, put in a bit of tax file number system, whatever you like, the resources are very, very large because the bank's very, very large. That's just a wrong perception, and we can only resolve that by education because the heightened anxiety of the community at the moment is not conducive for our putting many of these arguments very directly. Yeah.
It seems the major banks have all become rather unintentionally significant equity providers to unlisted companies. To what extent would the banks' major problems at the moment not be there if we didn't have such a gap in the capital markets for equity to unlisted companies? And what can we do about it?
Well, I think that the point at which you potentially become an equity holder in a company is not when you restructure a loan or you even do something very creative by being in equity, not in lending. The point at which you potentially become involved is the day you write the loan. If you make a mistake then, even though you may be called a creditor, even a secured creditor, the fact of the matter is that you and your customer are somewhat interwoven into one another's affairs, and that means he gets a shot at the bank's equity if it goes bad, and we get a shot at his later if we want to hang in there. On thinking this through, we have come to the conclusion that it is almost invariably unwise to restructure a loan and take equity, because the point that you're at there is usually the point of no return. There are occasions where a business may have, in whole or in part, may have some residual goodwill that can form the basis of trading over a period of time and give us both a chance at working it out. And in those cases, we'd look to try and do it. But we are very reluctant. And that reluctance comes from thinking about our depositors. The problem with the provision of equity to businesses is that nobody seems to be able to crack the problem that many people, particularly in smaller businesses, don't want to share their equity with anybody. The psychology that goes with taking the punt, applying one's immense energy, having the vision and getting the company going, seems to be consistent with wanting all of the returns naturally and not sharing the equity. The other problem is that the fundamental reality about equity is that you've got to have a certain amount of it, otherwise you shouldn't be there in the first place, and many businesses start undercapitalised that just shouldn't have started. Now, I think this is why the Industry Commission and others have such difficulty with this subject. We have a preference for an equity ratio of 80%, that's 80% equity and 20% debt, for most rural businesses. We believe that the volatility of those businesses is such that it requires that much equity. So if a lot of people are going to be encouraged into business at inappropriate ratios, then it's always going to be difficult to solve the problem. I don't have any magic solutions except to say that we are not going to confuse debt and equity, and we do no service to anybody by lending to those undercapitalised businesses.
Good. I think we've got any more questions. I'd like to ask Dennis Nettlefold of Cause Chambers Westgarth to close proceedings.
Thank you, Professor Miller. I have two very brief tasks to do. The first one is to invite you all to join the partners in some refreshments in about 1 minute's time. The second one is to thank Mr Murray for his address tonight. I have partners of mine who practice in the credit law area who are forever complaining to me about the scope of the existing legislation and the draft legislation, so I sympathise with you. So I'd like to ask you, if you would, to join with me in thanking Mr Murray in the usual way.